Hi everyone, Courtney Ernson with Midwest Business Law talking about your small business strategies. Today we're going to be talking about independent contractors. As attorneys, this is one of the questions we get asked quite frequently, which is, when can someone be an independent contractor versus when is somebody an employee? Now in Minnesota, we have what's called a 9-factor test, and the 9-factor test, as the name implies, has 9 individual factors that are looked at in determining whether someone is an independent contractor or whether they are an employee. The most common or the most weight that's given to one of the 9 factors is the means and method. So as the employer, are you giving this person the tools that they need to do their job? Are you telling them how to do their job? Are you directing them? Are you basically overseeing what they're doing? Or are you just saying, here's the job, this is what I need done, let me know when it's done? That's really kind of that big difference between the employee and the independent contractor. Now, as you can see, I've got kind of the sad face for the salespeople and the happy face for the laborers, because in construction, I would say most commonly the salespeople are often misclassified as independent contractors, whereas the laborers more commonly are true independent contractors. So they have their own tools, they have their own crew of people that do the work, they're actually doing work for other companies, whereas most often the salespeople are pretty much working with one company, and they're, everything's kind of laid out for them. So they're not actually a true independent contractor, regardless of whatever that document that you had them sign says that they are or not. One of the biggest mistakes that I see in terms of moving into that misclassification is providing company stuff. So are you giving them the branded, logo, polos, t-shirts, sweatshirts, or do they have a truck wrap or a truck sign that has your company name? Are you giving them a company email address? Or do they have, I've also seen the email address where it's, John Smith, whatever, roofing @gmail.com, something like that, but it still implies that they're working with that particular company. Business cards, understandably, when someone's going out to represent the company, you don't want them to have, John Smith independent contractor business card. You want it to be for your company. But that's one of those things that definitely shows that they're not a true independent contractor, that they are probably an employee. Mandatory meetings is another thing. So, sales meetings, production meetings, staff meetings, things like that. Having somebody required to be at a meeting is definitely one of those kind of no-nos if you want to keep somebody classified actually as an independent contractor. Same thing with scheduling meetings or jobs. So if you're, hey, salesperson, I've got a 9 o'clock, a 1 o'clock, and a 2 o'clock, here's all the information, let me know how it goes. That's not something that should be done if somebody is an independent contractor. They should be setting their own appointments, having their own communication with these individuals. Same thing with on the labor side, performing those jobs. Giving them the tools. So again, more on the sales side, often what we see is, hey, here's a company iPad, here's the login information for Buildertrend or AccuLinks, here's whatever tools that they need. Here's some, siding samples, things like that. Those are not something that an independent contractor would be provided. And then this is one I see quite often where I think a lot of the business owners think they're trying to be a little too clever. So rather than saying, oh, I'm providing you a company phone or a gas card, we'll just reimburse you for whatever charges you have. That's not going to hold up in terms of keeping that person classified as an independent contractor. Obviously, the biggest question then is, so what? Okay, so I did all these things, so what? In 2019, the Wage Theft Prevention Act was passed, and since then the Department of Labor has hired full-time investigators to look into whether or not wage theft is happening. The Department of Labor has also identified construction as one of the #1 kind of areas of work where they believe wage theft or employee misclassification is occurring. Now, no, it's not just the Department of Labor that could come after you. The insurance companies are also a big driver behind this law, because what the insurance companies want is the premiums. And so if somebody is classified as an independent contractor, the insurance companies obviously are not getting those insurance premiums. And so the insurance companies are definitely making a strong push to go after these individuals who are misclassifying independent contractors. The Attorney General's office has also prosecuted a number of cases against some larger companies for wage theft. Now, know that if you have a disgruntled former independent contractor who decides to make a complaint, a competitor, whomever. Another thing that has happened is if you are being investigated by the department for something totally unrelated to wage theft, but the investigator sees something or hears something that leads them to believe that there might be wage theft going on, they will also launch an additional investigation into that too. So if a company is found to have violated this law, the insurance companies are going after them for the premiums that they missed out on. If the Attorney General or the county attorney decides to criminally prosecute, if the investigation finds that the company, whether it's a single person or a number of people, stole over $35,000, then they could classify that as a felony, which could carry up to 20 years in prison, as well as a $100,000 fine. Now, we haven't seen anything that crazy yet, but the Merritt Drywall case is a good example of a construction company, probably like a lot of construction companies out there, didn't really know what they were doing wasn't the right thing to do because, as I'm sure most of you that are watching this think, well, everybody does that. That's how this industry works. But unfortunately, that's not going to be good enough anymore. And so just know that there could be not only, financial Department of Labor license issues and or criminal stuff. So it could potentially be quite a big deal. So just be very mindful if you're classifying someone as an independent contractor to make sure that they truly are an independent contractor. And the last thing is that if you are found to be guilty of wage theft, you also lose out on your ability to bid on public projects, which for those of you that do government work could be a devastating blow to your company. So thank you very much for watching our small business strategies.